All you want is out. At this point in time, he's going to say, well, I'm going to continue this matter for a week or 2 weeks until August the 22nd or whatever it's going to be. Now let's talk about the matter of bail. Mr. Gordon, we're going to have to impose some kind of bail. I see that bond has been set at $500. Do you have any comments? Yes, Your Honor, I qualify to be released on my own recognizance. I've been into the courts of Idaho numerous times. I think I've argued 20 or 30 cases in the state of Idaho, and I've never missed an appearance. I have children in school. I'm a resident of Boise. My address is here at 1205 North Roosevelt. I qualify in every particular to be released on my own recognizance. And I demand that the court act pursuant to Rule 46 and release me on my own recognizance. Mr. Prosecutor, do you have any rebuttal? Now the prosecutor comes into the picture and he says, well, this Mr. Gordon he's got a record as long as my arm. Well, he's been arrested about 20 or 30 times, and he's in and out of jail on such a regular basis here. He practically has his own room, and this guy he just has no respect for the law whatsoever, Judge. And we think it would be appropriate to set some kind of bail on this man because he's such a lowlife, and he's such a real bad fellow, and he sets such a bad example here in the community, sir. I don't know what his argument is, but it comes up, and he'll have some kind of frivolous tripe to bring before the court to punish it. See, what they want is an interest-free loan of $250 or something like that for 6 months while this case is being adjudicated. And the key is to keep that money out of those pagans' hands. Got that? Keep that money out of their hands. Money is what makes their little empire go around. As Mahatma Gandhi once said, you know, the British are spending a fortune here keeping me in poverty. And that's exactly what they're doing. You know what it costs the state of Idaho to keep me in poverty? It costs me a hell of a lot more than I'm worth, I'll tell you that. And that's what you've got to do. Now the judge is sitting up there. Now, I had a judge tell me that there wasn't any judge in the state who'd set bail on me, and I said, well, that's wonderful. What you need to do is develop a track record. Now, if you've got a history of not making your appearances, you know, you've been held for contempt of court because you just ignore your court appearances, you can forget that. They're going to set bail. Now, there's a little problem here with setting bail, of course, and we'll get into that one in just a moment. But the first thing is, Rule 46, and you should be released on your own recognizance. Now the judge sits there and he says, well, now, Mr. Gordon, he'll ask you a list of questions. And the judge, in my case, well, I don't know, they set bail on me not long ago, $2,500 on a felony, and they'll want to be charging you with felonies before long because they want to hang that felony on you so you can't run for office. See, they'll brand you as a criminal, like this Solzhenitsyn, you know. You stop and think about it for a moment. You know, Jesus Christ was convicted for treason, wasn't he? He was executed, whether he had trial, whether the trial was lawful or not. My goodness, if he came out here walking the streets of Ada County, he couldn't carry a gun. He's a convicted felon. And Paul and Peter and all those guys. Yeah, all those Christians. Look at this guy, Joseph Smith. You know, what if he were alive and walking the streets today of Salt Lake City? They'd throw him in jail for being some kind of criminal. I don't think they'd recognize him. Solzhenitsyn's thrown out of his own country. All right. So keep in mind, keep the money out of their hands. Now what are they going to do? They're going to say, the judge may say, well, I'm going to set your bail at $250. Well, wait a minute, Your Honor. You're going to set bail at $250. What do you want me to pay you in? I don't have $250. And I haven't had $250. You have $250 Federal Reserve notes? Well, Your Honor, under Idaho Code, two things here. Number one, I'm charged here with tearing up a pair of coveralls. The coveralls can't cost $50. And for the court to charge $250 bail for a lousy $25 or maybe $50 set of coveralls is a violation of my Eighth Amendment rights because it's excessive. I've never missed a court appearance, and so what we're faced with here is punishment and vindictiveness prior to trial. We don't have any issues before this court. We don't know whether I'm guilty. We don't even know if we've got the right jurisdiction. And to charge me $250 bail is vicious and malicious. Now, the prosecutor over here doesn't have any reason to believe I'm not going to make my appearances, and the only issue before the court is, am I going to appear or am I going to jump bail? And there isn't any reason to suspect I'm going to jump bail. And in addition to that, the Constitution specifically says that only gold and silver can be charged in public business by a state court, and this is a state court. Article 1, Section 10. We have another problem statutorily, Your Honor, because in the state of Idaho, all accounts are kept in dollars, cents, and mills, and that's Idaho Code 2822-101. And I'm invoking state statute and my constitutional rights under Article 1, Section 10 and Rule 46 in this matter. Now, I don't think any judge in Idaho is going to hold you. But let's suppose they do. Let's suppose they hold you. Got one or two choices now. Do you mean that this court is going to hold me for trial? When is the trial going to be set, Your Honor? Well, we don't know. You see, at this point, it's going to be a week before I can come up to arraignment. If I were to plead guilty to this, you wouldn't charge me with 5 to 7 days in jail. You'd charge me a fine, so therefore I'm being punished. And I want the court to note that if I'm kept in jail, the Argersinger rule comes into view here. Argersinger versus Hamlin clearly says that let every judge know that where a misdemeanor is involved, when there is no counsel, there is no jail. Now, are you going to hold me in jail in violation of Argersinger versus Hamlin? You see where you're putting the judge now? You haven't even been convicted yet. There isn't any reason you're not going to make your appearance. Now you bring in Argersinger. Bang him right over the head with it. Now let's suppose the judge says, I'm going to hold you in jail for $250 and you'll stay here until trial. You know when trial's going to be? 2 or 3 months from now. Bare minimum. Don't pay bail. Let them put you back in jail. Now file a writ of habeas corpus. With a writ of habeas corpus, maybe you'll be in jail for 2 or 3 or 4 more days. That's where your friends on the outside come in. Always force them to bring you out on a writ. We did that in the early days, and they don't force writs anymore. The Supreme Court of the state of Idaho must have got on the telephone and called them out at the jail. We don't want to hear any more writs from George Gordon and Bob Halston. See how that comes down? Now, when you're a first-timer in your little county, wherever you are, they're going to bring you into their courts, and they're going to drag you through every crack and every knothole they can for the first year. And I'll tell you where you really stop them from sucking eggs, and that's when you start filing your first lawsuits against them. You need some people out there who are judgment-proof, and you haul that jailer, you haul those judges in, and you charge them with violations of Title 42, and you let them know that as a matter of public policy, and every judge will know that the judges are going to obey the law. You know, you've got judges down here. Here's Rule 46. I just laid it out for you. You got Rule 46. You got Argersinger versus Hamlin. I'm hauled into jail. I've got no counsel. The Supreme Court of the United States has decided over and over and over and over. I mean, you know, even the Supreme Court uses words like, we are perfectly satisfied with our previous decisions. And these cases continually being brought before us are meaningless. Time after time, cases are brought before the courts that have already been resolved. And the court uses, it is settled that. It is well settled in our court. And yet, they keep dragging citizens in because every citizen has to argue his position every time before the court. The lady that rode the front of the bus and wouldn't get on the back argued her position. Every black man has to argue that position. It's when you get 5 or 10 people that go into the jail and say, Argersinger, that go into the jail and say, Davis versus Mississippi. And the judges say, oh, we've heard all those stupid arguments before, and they're specious and without foundation, and they don't have any merit, and they're frivolous. Let me ask you a question, Your Honor. I'm glad you brought the subject up. Is it your position that Davis versus Mississippi is specious, frivolous, without foundation and merit? Is that what you're telling me here today? Well, these cases have been filed by 50 of you people. Your Honor, excuse me, 50 of my people? Will you please itemize the 50 of my people who have filed these? Well, boo, 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 boo. Can you name one of my people who have filed these? Well, this guy, Dave Gibson. What is it that makes him my people? Well, he's one of those constitutionalists. Are you telling me that a constitutionalist is some kind of a subsystem, a subhuman? He's some kind of a subnormal person? Is that your position? Well, Mr. Gordon, there's a number of these same arguments have been brought before the court. Your Honor, let me ask you another question. Is it your position that these briefs and motions filed by other persons are lies, that they're untrue, that the Supreme Court's lied to us in the Davis and the Powell cases? Is there something wrong with the Supreme Court's decisions? Well, our courts have ruled that they're off point. Well, is it off point in this case? If he says yes, he's obviously out to lunch and off the wall. He doesn't even know in this case. We haven't decided any issues on the facts or on the merits of the case. If he says yes, well, Your Honor, it's obvious that you're prejudiced. You've already made a determination that my arguments are specious and frivolous, and you haven't even heard them yet. I haven't filed a single piece of paper on the court. You don't even know what my position is, and you've already said that my position is specious, frivolous, without foundation and merit. And it's obvious that you're prejudiced, and I demand, as a matter of the rules of the canons of ethics, that you disqualify yourself from this case. Now you see what you've done? And if that judge doesn't disqualify himself, then as a matter of public policy, he needs to be sued. And it won't take very many of those Title 42, Section 1983 suit friends to make your public officials aware of your position at law. You may lose. Who cares? I sued him for $700,000 not long ago, and I'll tell you how it comes down. Heads, I win $700,000. Tails, they spend and lose $20,000. And to show you how fair I'm going to be, I'll let you flip the coin. All right. Now we're up to, and I'll just bet you they're going to let you out of jail. If not, then it comes time for the next line of defense, and that is the writ of habeas corpus. So let's take a look then at the writ of habeas corpus. Over here, when you turn to number 6, you'll find the motion for writ of habeas corpus that Bob filed for me while I was in the county jail. Let's run through a writ of habeas corpus. I used to say that a writ of habeas corpus would be one of the last items that you'd ever need to use in a courtroom procedure, because they're ordinarily so, they're just not necessary. You just don't use them all that often. I used to say that. But that's not true. I'd say in the last year and a half that right here at the school we've probably filed a dozen writs of habeas corpus in our state Supreme Court, our district courts, for all manner of cases and types of cases, because the thing that we found here was that they'd arrest us and put us in jail and then set bail so high that we couldn't meet the bail. All right? When they do that to you, then you need a writ of habeas corpus. If you post the bail and come out, they then have an interest-free loan. They have this big club to hang over you. If it's at all possible, you ought not to post bail. Now, that isn't to say that you should never post bail, because Bob, for instance, was up in Seattle, it was Spokane, and they grabbed him for a concealed weapon or something like that and set bail at $300, and there you are, 500 miles from home, and you want to come home. So when you go to the bail setting hearing, you should move to have bail reduced, because oftentimes the prosecutor will set bail at $1,000, or that's his recommendation. And then if you fail to object to that, remember, failure to object timely is fatal. All right? So now you've moved the court to reduce your bail, and the judge refuses. Now, this happened to me not long ago. And if you've got the time to spare, you should stay in jail, because the longer you spend in jail, the greater the damages. Now, to give you an illustration of that, we had a young fellow that was in jail 28 days. He'd have been
driving down Chinden Boulevard here in Boise or in Garden City, and he allegedly exceeded the speed limit by 10 miles an hour. They arrested him, impounded his vehicle, and put him in jail and forgot him there for 28 days. When that happens, you have a tremendous Title 42 action to bring against the government. And that's, of course, what you want to do, is to bring that action. You want to help them, if it's at all possible, to violate your rights. In that case, all the policeman had to do was to write the man a ticket. But no, they wanted to punish him. They like to have what they call, or what we call, curbstone court, with Officer Schmidley presiding. All right, now, when that happens to you and you're in jail and they set you your bail at $1,000, you refuse to come out at the bail setting hearing. I don't have the money, I'm sorry. You can raise the money issue. What are you going to charge me money in, Judge? Are you charging me bail now that's impossible for me to pay? Now, you've brought up Rule 46. Nothing has worked so far, so now you want your friends on the outside to file a writ of habeas corpus. The moment you get into jail, you should be making demands upon your jailers for pen and paper to write a writ of habeas corpus, even before you come up to the bond setting or the arraignment hearings, because that's a right that you have, and you need to demand that right, and you need to be the belligerent claimant in person who's consistently demanding counsel and pen and paper to write writ of habeas corpus. And of course, they won't give you either one. And they become reversible errors then. In other words, you've been denied fundamental rights in the jail. And those are called appealable issues. Now let's take a look at the wording here of this writ. It's not very long. I think it's about 3 pages or so long. We'll just buzz right through this. And let's see what happens when we take a look at a writ of habeas corpus and where do we file it. Comes now this free man, Robert Hallstrom, in behalf of the defendant George Gordon, who cannot motion the courts in his own behalf because his public servants have again incarcerated him unnecessarily and unlawfully, to move the court to order his release from the Ada County Jail for the following causes. Now you notice that when you address the court, what you have here is a motion. Instead of motion, it should more properly be petition for a writ of habeas corpus. So let's put a circle around that motion up there. And when you write it, the fellow that wrote this made a little mistake here. Motion would be all right, I guess, but petition would be better. And then when the petition is granted, then it becomes a writ of habeas corpus. All right, now you'll notice that in your specific purpose statement, you've stated that he's being held illegally and unlawfully, and he's being held where? In the Ada County Jail. You have to say where he's held, what he's being held for, how he got in there, how long has he been in there. Let's go on and see what's happened here. Let's see whether we've covered all these points. The defendant has committed no crime under the common law, nor even under statutory law, that under the circumstances would require incarceration. I think I was arrested for a driver's license or something like that. The defendant has been jailed because of minor traffic infractions, and more specifically because he demanded probable cause, a search warrant, and counsel before answering any questions at the alleged scene of the crime. Remember what that produces. You've brought forth the Supreme Court's case on, I believe it's Johnson versus U.S. or something on that order, and you've demanded counsel, and you're entitled to counsel. Remember the Miranda case, you're entitled to counsel, and counsel of your choice, or to speak with anyone else with whom you want to speak. Now, you're the person who's going to be taken before the judge, and it's imperative then that this writ get moved into the jail so that you'll have an opportunity to read it and study the issues that your friends have set out in the writ for you. If they won't let you have the writ when you appear in the court, your friends need to keep abreast of where you're going to be brought forward, and then give you this writ and then move for a 15-minute recess so that you can read this writ and talk to one of your friends. Then you're going to have to argue each and every fact and each and every one of these allegations on the face of this writ. And this writ had better have all of the information in it. The defendant's property was towed away from private property without his consent nor under complaint of the person owning said property. There's a fact. The defendant is being held in the Ada County Jail on simple traffic infractions and is being denied visitors and counsel. 2 more facts. Another arraignment was supposed to be held this date at 2:15 p.m., but has now been apparently set forward to Monday. It would appear that his public servants are attempting to harass and intimidate him into submission. A call to the Ada County Jail at approximately 2 p.m. this date revealed that, quote, "We have taken all of this GD crap we're going to take." You see, now the person who made the telephone call should appear in court, and you, the person who's being held, should put this person who made the telephone call on the witness stand and let him testify as to what he's listening to, what is occurring out there in the jail. And until he starts cooperating and finishes the booking procedure, he'll not be allowed any calls or visitors, as per the lieutenant. So there was some lieutenant out there. Now here's where you could have either the fellow that wrote the writ for you or someone else who will go into the courtroom and testify as to what's occurring out there. They're beating him, they're holding him, they won't let him have counsel, etc., etc. Number 5, the defendant was arraigned on the traffic infractions at approximately 9 a.m. this date and was released on his own recognizance, providing he would willingly submit to the taking of fingerprints and a photo. The defendant stated he would submit only if the court would order the taking of said data, which the court refused to do. This was interesting. Pursuant to Davis versus Mississippi, the court has to order the booking process, the fingerprints being taken. If you're ordered to give the fingerprints, then go ahead and give the fingerprints against your will and over your objection, and so sign on the fingerprint card. Then what's happened, you've been compelled against your will and over your objection to testify against yourself. There was one judge who, in error, we believe, ordered me to do that. And so I just tripped right in there and said, "Hey, fellas, let me show you how to put these prints down." See that? Now, if they were to use those prints against me, it was done under court order, wasn't it? It was done against my will and over my objection. That's the only time that we've ever had a judge do that. Since that time, the judges, being crafty fellows themselves, have always said, "No, we're not going to order anything. That's your problem in life." Going on then, the defendant is no stranger to the Ada County Jail, and almost every person there knows him on sight, and it's difficult to understand why more prints and photos are needed. Yeah, that's true. I think they all know me out there. Number 6, the presiding judge said that the Supreme Court has ruled several times on the issue of fingerprints, and that the arrested persons must allow the procedure. The defendant stated that the taking of such information would violate his 4th and 5th Amendment rights, as the information could be the starting point for an investigation against him. And if such information was found, he wanted immunity from prosecution. I believe that's the judge I just referred to who said, "I'm going to order you to give them your prints." And that's exactly what they need, but they need probable cause. Read that Davis versus Mississippi case again and see if you can't pick out there what the Supreme Court is talking about when they're saying that fingerprints are just like testimony against yourself. Number 7, the defendant is only being uncooperative in that he is demanding his rights under the Constitution of the United States. And remember what the High Court has said? We find it intolerable that a person would have to give up one constitutional right to assert another. He refuses to be a slave to his government without due process of law and is simply demanding equal protection under the law. He simply refuses to answer questions without counsel, which is completely within his rights. Well, certainly, that's within the Miranda doctrine. I'm not going to sit here and answer questions and give up my fingerprints unless I've got counsel. It appears that on the one hand, his public servants may understand that he has the right to remain silent, but wish to punish him for exercising that right. And boy, you're going to find that in the opening rounds. They'll hand you a little card and they'll say, "Do you understand all of your rights? Here, sign this." Oh, wait a minute. Hold a minute. Let me read this. You have the right to remain silent. You have the right to counsel present during all stages of the interrogation when you're held in custody. Wait a minute. Am I being held in custody? Am I free to leave? I mean, you can just take a look around in this jail. Always ask the question, am I free to leave? No. Oh, well, I must be in custody. Well, let's see. If I'm in custody, then I demand counsel present during all stages of these interrogations. Just sign the card, dummy. I can't sign the card unless I have counsel present to advise me as to whether or not I should sign this card or not. And I have a right to it because you told me I did. I wouldn't have known I had this right if you hadn't just told me I have the right to counsel. And then they'll say, when you sign that, then you can have counsel. After I've signed the confession, I don't need counsel. So I think I better get counsel here before. Before I sign, I want counsel. You see, here they're offering you, they're telling you that you have this right to counsel, but you can't have it until you make the confessions. Sometimes these policemen out here don't have much in the way of common sense. They're not too smart when it comes to just thinking a little bit logically, thinking it through. Ask them questions like that. That's half the fun of going to jail, is to ask this guy to think for himself. And when you do that, the conversation breaks down and you can kind of smile and chuckle a little bit. Turning over here on page 3, this is number 8, it says attached is a copy of a motion for the return of fingerprints and photographs, which has been filed with the lower court and has yet to be argued. It completely explains the defendant's position on the issue and is based upon cases used by the government in support of its position. This person has researched the issue and fails to find any Supreme Court cases as alluded to by the courts. In other words, remember from Miranda, the police oftentimes give false legal advice. They'll do that all the time. They'll say, hey, the Supreme Court's already ruled on this fingerprint and counsel issue. You have to sign this document before you can have counsel. They just sit there and lie to you. And I don't know if they do that intentionally. I think they do it because they're stupid. That's my observation based upon the number of times that I've been there. Now, once in a while, you'll find a policeman that seems to know a little bit of law. When you find one like that, he just doesn't hassle you. So you really can't tell whether he's smart or dumb. The ones that are dumb will come over to you and they'll start quoting law to you, and say, well, blah, 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 and you have to do this and that. Just like the Supreme Court told us in Miranda, they'll give false legal advice. The cases typically cited by the government do not, in fact, support the taking of prints and photos when the defendant objects and physically resists. Okay, remember, the belligerent claimant in person. You've got to physically resist. Now, that doesn't mean that you must resist the officer by kicking him in the shins and drawing blood, because if you do that, that's aggressive. What you must use is passive resistance, the kind that Mahatma Gandhi used. I'm not going to open my fist. I demand all of my rights. I'm not going to cooperate, and I won't put my fingers on that card. Okay? In all of the cases, the slaves consented to the taking of the data, and when they were found guilty, tried to use fingerprints as an appealable issue. Remember in Lesson 13, we went through the 7 issues that the Supreme Court, or the 7 rules that the Supreme Court are going to use to determine whether or not you've asserted your right timely. Now, this fingerprint issue could nullify the entire trial proceeding. That one paragraph right there could be the winning issue. Picture it like this. You're in the jail. They're compelling you to give fingerprints. You won't give the fingerprints, and they charge you with obstructing and delaying. Well, you're not obstructing and delaying the officer. First of all, those 2 words are the antithesis of obstructing and delaying. That has to be done by a third party. You know, if the policeman's trying to arrest you or serve you with process, to obstruct and delay would require somebody else to do that. You can't. But what if they force you and they take these fingerprints and violate your rights? Now you've got your Title 42 suit, and now you've got your issue for reversible error or trial de novo, that they've compelled you to give these fingerprints. What if you're wanted somewhere else? There might be some warrant out for you in some other county for some other charge. And you would use this then to suppress that evidence. Then they'd have to dismiss. All right, number 9. This person fails to find the alleged reference or Idaho code that requires citizens to submit to the booking procedure. Boy, that's a keen one. Yeah, where does it say here in Idaho code that I have to submit to this booking procedure? Legal writers tend to support the position that there are few such laws, if any. For example, LaFave's book, Arrest, 1965, page 380, states, although booking operates as a safeguard in this way, it is not generally required by law. And the reason it's not required by law is because it's a violation of your Fifth Amendment rights. Modern Criminal Procedures by West, 1974, page 7, states, depending upon the severity of the offense, the suspect may be fingerprinted and photographed. Okay? Depending upon the severity of the offense. Well, now that may or may not be. We don't know. That's some editor's opinion. We don't know if that's law or not. Number C, in Search and Seizure by Wayne R. LaFave, page 5.1, 1978, it states, fingerprinting and photographing may be required by the circumstances of the case. Circumstances of the case, well then, who's going to decide what the circumstances of the case are? Is it based upon felonies? Is it based upon misdemeanors? Is it based upon local procedure, booking procedure, statute? See, we don't know. When we go to the Supreme Court, we can find out in short order. It is common knowledge that even on the arrest of a citizen for overdue parking tickets, that the Ada County Jail will take prints by force if necessary. They used to take them by force here, but they won't do that anymore. Now what they do here is charge you with obstructing and delaying an officer. For these causes elaborated above and in the attached motion, this person moves any judge of any court to immediately release the defendant from the Ada County Jail until these matters can be litigated in a court of law. Now, there's no page 4 on here. It wasn't necessary. All it was the closing. And that's all there is to a writ of habeas corpus. It can be 10 times this long, or it can just be 1 or 2 paragraphs in length. The writ of habeas corpus, or the petition, rather, for the writ of habeas corpus is filed. We like to do it like this. It has to be done in order. In other words, you wouldn't file this with the Supreme Court of the United States or with a federal district court because this is a state case. So what you do is you take it up to the district court. Now, writs of habeas corpus have first priority on the docking schedule. If they're going to have arraignments and they've got a writ of habeas corpus, they listen to the writ first. If they've got a trial and a writ of habeas corpus, they'll listen to the writ first. It has top billing. If there's a civil case, a trial, and a writ, they do the writ, then they do the criminal trial, then they do the civil case. And you should be brought forward within a day or 2 of the filing of the writ of habeas corpus. Now, what we do is we file one today, which is a writ of habeas corpus in the district court, and then if we don't get an answer tomorrow, if we don't have a scheduling for bringing him forward, we'll assume then that the district court is dragging its feet in order to punish the man in jail. And they'll do this a lot of times. You know, you're a dissident, you're some kind of a reactionary here, and we want to put you in your place, and so the judges they'll schedule it all right, but if you file it on Friday, you stay in jail the weekend, they'll bring you up for arraignment on Monday, set your bail so high you can't make it, you file the writ of habeas corpus that Monday, they don't listen to it on Tuesday, they'll listen to it on Wednesday at 4 o'clock. Okay, so Wednesday at 2 o'clock or 1 o'clock, you file another writ of habeas corpus in your state Supreme Court and give them an opportunity there to act on it by, Wednesday or Thursday. Now, typically what's happening here, the Supreme Court evidently gets on the phone and says, you jerks across the street, would you wake up? Because in the 2 years that we've been doing this, and I say we've probably filed 10 or 12 of these writs, I haven't counted them, but there's 10 anyway, there hasn't been a single person released on a writ of habeas corpus on the merits. They all get released mysteriously. The door's just open, the jail just says get out. You come to court and the bail is simply reduced to OR, things like that in every single case. So I think what's happening is your state Supreme Court is the one that's putting the pressure on the lower courts to act. We don't want to listen to these writs because, you see, the next place that you're going to take this issue is to your federal court, which would be your federal district court. Now, the states want to keep these issues within their borders. And after you have exhausted all of your remedies within your state, which is a must, you must exhaust all of your remedies, then you go to the feds. And the feds will take action because the feds are interested in civil rights issues, and you'll find that time after time after time. Now, what happens if the writ of habeas corpus doesn't work? Depends on how long you want to stay in jail. I don't know, as we've never had a single case yet where we filed a writ where the man hasn't been released. Now, pursuant to the rules, to be released OR, you have to have children and family and ties and job and et cetera in the community, and I think most of us would qualify that way. If you're an itinerant from California passing through Idaho, you've got a problem. You may have to post some bail. We noticed that up in Spokane. Always post bail under threat, duress, and coercion, and get that on the record. Now, there's one other thing that you do before you post bail, and you should plan for this before anyone goes to jail. In Idaho, under Chapter 19, there's a section on bail, and it gives you the rules of bail. You don't have to post money, you can post property. So someone of your friends should have a piece of real estate within the county, and then you'll need 2 witnesses who will guarantee your appearance. And then you go to the court and you file based upon the rules wherever you happen to be. For instance, here in Illinois, okay? If you look up the word bail, which in Idaho is in Chapter 19, you can run through the bail section and it'll give you all the rules. After you've done it once, it's no big deal. It's no big thing. I think what I'll do is at this point in time, I'll put bail in because that's a nifty line of defense. And why don't we just take a moment here and pause and let's read the bail requirements, because right at this moment in time, if the writ of habeas corpus fails, you may want to file and put up a piece of property as security for your appearance. Let's take a look at that here in Idaho Code. Okay, I'm on Title 19, 2909, and I'm going to send you a copy of this. It'll be in this lesson. Now, in your state, you're going to have to take a look at the bail requirements, and you're going to have to practice. Here in our state, we have these forms made up under Idaho Code 192909, and you'll have to take that to the judge pursuant to your particular judicial rules of your district. Like, for instance, we have rules in the 4th Judicial District of Idaho, and you have to have 2 persons who will go up. Sometimes you'll have to take the stand and swear that you've got property and that you've got the assets and that you can cover the bail of $1,000 or $5,000 or whatever it is. But by doing that, you deprive them of one of the vitals, and that's money. That's an interest-free loan. Another thing is you'll find some scams going on like they have in Spokane as an example, where there's 2 bail bonding companies owned by judges and prosecutors. Everybody in the Spokane County Jail posts bail. They make sure of that. I mean, you've got some graft and corruption up there in the judicial system in that particular county, and there are other counties. I mean, listen, you talk about graft and corruption. Anywhere that you don't have a grand jury working, you've got graft and corruption. Now, that's the way you handle this thing of bail. There's about 10 or 15 statutes here. It goes to 2911, justification of bail. You need to study and look those up. It's no big deal. It doesn't come up very often. And so let me make this comment here as we close out this side of the tape. On these issues that don't come up very often, like writ of habeas corpus and bail, don't worry too much about memorizing that kind of thing. Remember that the Edison formula calls for, or the Henry Ford formula calls for, rather, putting your finger on the button and getting the fellow that knows and understands how to do this to come in. Okay, now how do we handle this? Or when it comes down to the nitty-gritty, whip out the book and say, okay, bail, let's keep from paying them money. Because they're always after those interest-free loans, and they're always after that 10 or 15% bail profit. Take that away from them. We take that away from them. We take, by use of Argersinger versus Hamlin, we take the jail sentence away from them. We take the fine away from them with the money issue, and we've taken all the fangs and all the claws out of the cat. Okay, let's go on to the next issue then. Let's pull out motion hearings, and let's see how we use motion hearings as a line of defense. That there's 2 things that we're after when we're doing a court case. We're after victory on 2 fronts, procedure and law. Okay, remember those 2 items, procedure and law, procedure and law. Drill that into your mind so that every time you're confronted with a court case, procedure. What do I do in procedure, and what do I do as a matter of law? Because everything you do is geared to going to the Supreme Court of the United States. You don't do anything for a magistrate, judge, jailers, policemen. Everybody you talk to at the lower levels are people who probably do not understand what you're doing, and you're casting your pearls before swine. But the High Court has said,
you must exhaust every remedy within the borders of your state before you can go to the Supreme Court. And remember in Lesson 13, these 7 rules that you must abide by if you're going to qualify your case to the Supreme Court. All right, now we've covered those lines of defenses up to and including the writ or the petition for a writ of habeas corpus. All right, now let's delve into Lesson 9. Pull out Lesson 9, that's this whole case. Sample criminal case for use with videotape, Lesson 9, and let's turn to the table of contents. And let's run through each and every one of these 38 items, I believe in this case, 38 items that you're going to go through. This is like a checklist. You're going to write an appeal when you get to the end of your case, which is your last line of defense, remember, is the appeal. Everything you do is geared to that appeal because you're going to lose in front of the jury unless you're one of those rare exceptions. And I've argued many cases in front of the jury and lost every one of them. And we've only got 1 or 2 students who have ever won a case in front of a jury, and we call those flukes. And I sure don't want to pin my hopes of victory on a jury decision because 1 time in 100 you'll win in front of a jury, the other 99 times you're going to lose. So therefore I'd rather pin my hopes on those 99 times that we're going to lose and convert those into wins. And you can always convert those into wins because your adversaries in a light case like traffic, misdemeanors, taxes, and things like that are really only prepared to go to the jury verdict because the costs begin to mount. Not here voluntarily. I'm here out of fear, threat, duress, and coercion. I think that if I don't appear today, based upon this prosecutor's invitation, this faulty service of process, that you'll issue a bench warrant and have me arrested and put in jail. See what you do? Lay it out in spades on the record. All right, the next thing here you'll notice is 1A, a criminal complaint. Immediately, when you go to the arraignment, or even when you're going into appeal, I should say now we're going into the appeal. We've already made our objections at the arraignment. You bring up this complaint, and on your appeal you're saying the state of Idaho, and you raise the 8 major federal questions of jurisdictional problems that you noted with the complaint or the information. This is the state of Idaho versus George Gordon. This is a civil action in a criminal form. Let's see what happened here. This is number 1B, motion and order for injury to jail and resisting an officer. Well, I think this was the motion and order for dismissal. That's what it was. Yeah, they dismissed the case. That should actually be at the end of this case. Here you have a summons. Number 1C. Hereby notified a complaint has been filed against you. I'm looking at number 1C here. Okay, here's our complaint. And this is a summons. And this summons is now lawful. It comes from the deputy clerk. Now this is proper service of process. Notice the first service of process was garbage. In fact, in some instances, we don't even honor those. Just ignore them. Don't even go into court. I've done that a couple of times and then walked in and put on the record, I heard rumors on the street that there was a secret hearing today that involved me, and I'd like to have proper service of process, Your Honor. I don't want to listen to rumors on the street corners about secret hearings being held. I want the court to notify me. And in this case, they did. Okay, you'll notice that these very first items then were all administrative and procedural matters. Let's take a look at number 2, the list of charges against the jailers. I don't recognize that one. Statute on the charges. Motion for discovery. Okay, let's take a look at number 4, which says motion for discovery under Rule 16. Now, depending upon your particular state rules, which will probably run hand in hand with the federal rules, you take a look at what it is that you're entitled to, and you demand each and every one of those items. If it says that you're entitled to a typewritten transcript,